now I'm going to share my screen and we are going to dive into municipal liability land. Here we go. Again, our annual update compendium is an amazing Academy member resource. You can find it at trialacademy.org/annual update compendium. And there are 21 years of municipal liability updates in there for you to search and read to your heart's content. All right, we're going to get started with some messages from our sponsors. Again, these are the folks footing the bill, so I know you're going to be respectful, listen to their messages, and use their services. Here we go.
In the fast-paced world of litigation, communication and precision is key. Smart Advocate's all-in-one system outperforms the rest with unique, customizable features like built-in artificial intelligence tools that enable firms to manage, store, track, classify, and communicate like never before, which will help boost your firm's efficiency and profitability. Our system is not just software, it's your dedicated partner in your firm's success. Smart Advocate, a smarter way to manage your cases and your firm.
Walker, over the last 3-4 years, helped take the firm to the next level. They're providing you the leads that result in cases that ultimately result in settlements and fees for the firm.
Walker's a great system that works. Those days of being able to handle your own marketing are over. The quality of the good calls you get are truly there.
Walker helps produce leads, and that's the best description of expansion for me.
We like to take a comprehensive analysis of the client's financial affairs at the time of settlement, making sure that we formulate an appropriate financial plan so that they will never run out of money, whether that be with a structured settlement that provides lifetime benefits, so that at the end of the day, if anything does happen with the upfront cash portion of the settlement proceeds, they still have money coming in to provide for their daily living expenses throughout their entire lifetime.
Awesome. Again, many thanks to our fabulous sponsors. All right, we're going to take your CLE credit by a Zoom pop-up poll. Again, they'll magically appear right on your screen. If for some reason they don't, I'm going to read it out loud. You can always email us after the course, info@trialacademy.org. and we will magically process your credits. All right, it is my great pleasure to introduce our dynamic duo on municipal liability. These guys have been working together on this for a number of years now. We've got Mike Bersani you're at Michael's Bersani Calabanca. That's right? He's been the municipal liability author since this whole game got started. He also authors other stuff and has been a top student and professor at various places. And he serves on the Academy's board of directors. So if you have complaints about me, take it to Mike. We also have Dan Solinsky, who's at Leitner Wariwoda. Did I say it right? I think I did. Amazing. Been doing this for 10 years, a graduate from St. John's, started at the DA's office, but has been doing this plaintiff's thing for a long time now. Also likes to write for various publications and also serves on our board. All right, I'm turning it over to the two of you. Who's going first?
I'm going to go first, Michelle. Okay.
Right. Take it away.
And I'm going to share my screen so I can do my my PowerPoint here. Do you see my screen?
Yeah, it's thinking about it. There you go. Just put it into slideshow mode.
Oh yeah, that's right. I got to put it into slide mode. Hang on one second here. Slideshow. From the beginning. There we go. Got it?
Perfect. You're off to the races.
Okay. Well, as usual, Danny and I have agreed that we split this outline just about in two. And for some reason, I go first every year, probably because I take the first part of the outline. But here we go. I'm going to dig right in. And in today's outline, there's a Court of Appeals case I'll mention at the end. But before we get to that, I want to talk. There's a lot of cases that are helpful to us today, I believe, in learning how to make General Municipal Law 50E5 work for us. And just a reminder, when you sue a public corporation or a municipality, you have to file a notice, serve a notice of claim within 90 days. That's what the statute 50E says. However, that's before you can sue. However, if you're late, 50E5 gives you an additional time until the statute of limitations expires, which is usually a year and 90 days, to bring a petition to late serve a notice of claim. Now, the longer the wait, the less chance you're going to get of winning, of prevailing. So you don't want to wait. But let me just go through, and when they talk about the 50E5 talks about the factors the court considers in deciding whether to grant or deny the petition to late serve. And the main factor, the statute, in fact, says in particular, so that's the main factor the courts must consider, is whether the public corporation had knowledge, actual knowledge of the essential facts of the claim, or facts constituting the claim within 90 days or a reasonable time thereafter, okay? And by the essential facts of the claim is not enough just to know an accident happened. There has to be specific information so they have enough information that they need to investigate and they can investigate. The whole purpose of this statute is to give the municipality time early on to investigate, to defend their interests. So in this outline, there's some very interesting cases regarding how you, as a plaintiff or plaintiff's lawyer, can deliver that actual knowledge to the public corporation. Now, first, let's step back. Often, the accident itself provides enough essential facts for the municipality to have the knowledge it needs to investigate. You don't always need to notify them of this. Oftentimes, there's an accident, it's very clearly something went wrong, and they investigate. But sometimes, the accident happens in such a way that really, they're not going to be on notice or have knowledge of all the essential facts of the claim. So the question is, how can you, as the plaintiff's lawyer or as a plaintiff, help them get that knowledge you need to win later a motion to or a petition to late serve a notice of claim? And the cases, there's 3 cases I'm going to discuss. And the questions I have for you, think about this before I read the cases. Do you think that if you serve, let's assume for the hypotheticals that you have a case come into your office a day after the 90 days is up. So it's the 91st day after the accident. What if you serve a late notice of claim? You're latest after the 90 days. Just serve it anyway. Just serve it to give the public corporation actual knowledge of the essential facts of the claim. And then your thinking is, well, later on, we can bring a petition to late serve it and point back to that earlier notice of claim to say, look, they had the essential facts of the claim in that late notice I served. All right, that's one way. Think about that. We're going to find the answer in a moment. Next, what about just sending out a petition to late serve the notice of claim? Let's say it's you send out a petition, and the question there is, if there's been no actual knowledge before then, does the petition itself on that date, whenever the municipality receives it, does that give them notice of the essential facts? And the last thing is, what about a mere letter? What about you just send a letter, or have your client send a letter describing what happened and why you think the public corporation's liable? So now let's get into the case law to see what the case law says on this. Hang on one second. All right, here we go. So the Harry case, I think that's the right one. Hang on a second. There you go. I skipped one, sorry. So the Cassidy case on page 38. In this case, the petitioner served an untimely notice of claim. It was only 5 days late, 5 days after the 90s, okay? And later on, that plaintiff, several months later, brought a petition to late serve the notice of claim. And in that petition, they said, look, in order to show that the public corporation had actual knowledge within a reasonable time after the 90 days, they pointed back to this notice of claim that they had served 5 days after the 90 days. And the court said, no, that doesn't count, because a notice of claim that's served late without leave of the court is a nullity. And it's a nullity in every sense of the word. It's as if you never sent it. So you can't even rely on that to say that the public corporation had knowledge. It was never sent at all. So that's not the way to do it. Serving a late notice of claim without leave is a nullity, won't help you at all. So what about this? What about in the Harry case? You have the respondent, the public corporation, admitted receiving the petition to late serve with a proposed notice of claim attached about 3 weeks after the 90 days expired. And the court held, yes, 3 weeks after the 90 days expired is a reasonable time after the 90 days. That's good. We're going to grant the petition. And the actual knowledge, the court held, comes from the petition itself. When you do the petition, you have to attach an actual proposed notice of claim, and that tells the municipality all the facts they need to know about the claim. So when a case comes into your office, these two cases are teaching this, on the 91st day, don't do a notice of claim without leave. Rather, immediately do the petition. The petition itself will give them actual knowledge. The notice of claim will not. Now let's go to the third way, a letter. Walker versus Little versus Westchester Medical Center, page 59 of your outline. In this case, early on, the plaintiff herself, without a lawyer, sent a letter notifying the hospital, the municipal hospital, of her fall. And the letter was a pretty good letter, but it was a slip and fall case somewhere outside the hospital. But the problem was the plaintiff didn't say where it happened. And for that reason and that reason alone, the court here said that it didn't provide the public corporation with actual knowledge of the essential facts of the claim. An essential fact was missing. Where did it happen? So this case here, and I cited also in this screen to an old case called Franca versus Town of Cairo, but there's many cases, you can find them in all the appellate divisions, where a plaintiff sends in a letter describing the incident. And if in fact it contains the essential facts of the claim, the courts will deem that letter to provide the corporation with actual knowledge, okay? So here's the question, going back to screen one, if the first screen here, if instead of sending a notice of claim on the 91st day, all right, what if you just sent a letter? Or what if you had your client send a letter? The case law doesn't say that a letter is a nullity. It only says an untimely notice of claim is a nullity. And I think that might work because the case law is clear that a letter will do. So let's say, how can you make this work for you? Let's say a client walks in on the 91st day and you're really, really tied up with other stuff and you can't get around to producing the petition right away. It might take you a few days. You want to risk waiting too long? Have your client send a letter describing everything that happened, why they're liable, send it right away, get it to them. And then as soon as you can, get your petition in, which will also give them the essential facts of the claim. So I like when I look at these outlines, I try to see ways that we can use these cases to help us in our practice. And I think that is something you should consider. Now, I've already talked to you about how to deliver actual knowledge to the public corporation if they don't have it already. We've talked about that. Now let's talk about who at the public corporation has to get the knowledge. There was a case last year that I talked about, a Court of Appeals case called Jaime versus City of New York. And in that case, the court dealt with this issue. And basically the issue there was I'm not going to go through the facts of the case. I don't have time, but we're going to see some new cases that came out of this. The fact is some low-level employee of the city, for example, gets actual knowledge of what happened. But can you impute that knowledge to the corporation itself? And the answer is no. It's got to be a higher level employee, and you're going to see what the court says here. The court says, here are the best quotes from this case. The first one is, courts should not assume that every municipal employee's knowledge of essential facts is necessarily imputed to the municipality. Allowing imputation in every case would undermine the purpose of the notice of claim requirement, because not every employee's knowledge will necessarily afford the municipality an opportunity to commence a prompt investigation. And remember, the whole purpose of this notice of claim structure is to allow the municipality to do a timely investigation before the evidence gets stale. And the final quote, I think this is the most important one, is generally knowledge of essential facts by an actor in a position to investigate will suffice. So now let's look at the cases. All right. There's two cases on page 43. The first one, Grabco versus Rye-Neck Union Free School District. So this was a labor law case. There was a worker from a contractor who was power washing school awnings. And there were two custodians that were present and may even been helping him do that. And they witnessed the accident. And later on, when the plaintiff petitioned to late serve a notice of claim months after the 90 days has expired, so you're well into, you got to show actual knowledge. Remember, you got to show actual knowledge by the corporation within 90 days or a reasonable time thereafter. So we're getting to the unreasonable territory here. It brings a petition and tries to argue that because the two employees, the custodians, saw the accident, they had actual knowledge when it actually happened, and the court should impute that knowledge to the school district. The court said no, that's not going to do. It flies in the face of this Jaime case out of the Court of Appeals. Can't happen. They don't have any duty to investigate. They're not investigators. They don't. Their job is not to investigate claims, civil claims. Same thing in the Charbot case. There was a police officer who picked up a moped, put it on a truck bed, and apparently injured his back. He had a fellow police officer with him, either helped him or saw it. And when he filed his petition to late serve months and months after the 90 days expired, tried to turn the clock back and say, look, the city had actual knowledge of the essential facts through the co-police officer that was with him. And the court said, no, that flies in the face again of Jaime. The fellow police officer had no involvement in investigating civil claims for injuries. All right. The next court case, I like this case because it shows us two different things. I'm going to talk about two different lessons we can learn from it. Here, in the Crawford case on page 41, the petitioner was injured in a motor vehicle accident caused by a city employee driver. So it's a two-car accident. A city employee is driving one of the cars, is at fault apparently. And later, the plaintiff, again, months after the 90 days, brings a petition to late serve, a notice of claim, and tries to point back to the fact that the city employee was driving the vehicle, what actually caused the accident, and therefore the city knowledge of the accident should be imputed to the city through the employee. The court wasn't buying it, but the petitioner had a second argument. That was, he claimed that he saw an unnamed supervisor of the employee show up, and it looked like he was investigating. It looked like he was writing a report. But the petitioner didn't have actual evidence of who that was, what his role was, or anything like that. So the court said, that's way too speculative. But here's a question in my note at the bottom of the screen. I say to you, well, what about discovery? Can you get discovery from the city to find out who that unnamed supervisor was, what he was doing, whether he reported it upward? And you might say, well, wait a minute, we're not in suit yet. There's no discovery started. This is, you're asking the court to allow you to file a notice of claim. This is a pre-suit condition, so you're not in discovery yet. But can you get pre-suit discovery? And the answer is on the next case here, this Wisnowski case against City of Buffalo, page 27. In this case, you had a construction site owned by the City of Buffalo, and there was a contractor who had an employee working on this construction. And when he got injured, he testified that in fact, it was a fact in the record that he told his employer about the injury 5 days later, and that he believed that his employer likely notified the city about it. It makes sense, right? It's their construction site. And therefore claimed that they had actual knowledge. But here the plaintiff's lawyer did the right thing. This is really smart. There's a good lesson for you. He didn't just bring a petition to late serve a notice of claim. With that petition, he also brought a petition to get pre-suit discovery under CPLR 3102. And into that same petition, he brought in the employer of the plaintiff. And so he wants pre-suit discovery from both. He asked the court to grant the petition to late serve, but if the court found there wasn't enough evidence that there was actual knowledge, then, as a second argument, said, let me get my discovery. And he asked for all incident reports and correspondence between the two respondents, being his employer and the city, concerning the accident. And the court said, yes, absolutely, go for it. So when you're stuck in a situation, what Wiskowski teaches us is when you're stuck in a situation where you don't have the evidence you need to show that the city or the municipality had actual knowledge of the essential facts of the claim early on, and you think some discovery might unearth that, go for it. Don't just petition to late serve, petition also in the alternative for some discovery. All right. Now, also, I just wanted this a little reminder here, actual knowledge. If you look back at that first slide I showed you, I'm not going to go back right now, but the statute actually says, 50E5 says that actual knowledge by the public corporation or the insurance carrier or the lawyer from the municipality are all equally valid. So in this case right here, Benedetto, on page 44, the petitioner slipped on a tarp covering a hole in the floor at a school construction project. And the court held that the city had timely knowledge because the workers' comp carrier had it. So the workers' comp carrier for the city, the knowledge that they had is imputed to the city. Keep that in mind too. Actually, let me just go back for a second. So if you make your petition and you want to get some discovery on whether the city had knowledge, you might also want to get some discovery on whether their carrier had knowledge. That could be important as well. All right, now we're moving on to a sticky issue. I'm going to tell you right off the bat, because this is going to take a while to get through. I'm not sure how much. Michelle, how much time do I have left?
You're doing great. You're like 5 more minutes until we're about halfway through.
Okay, so I think I've got time for this. So, you know, the Court of Appeals in recent cases, and I got the Ferrara case on the screen, they've said over and over and over again in very strict terms that they require, anytime you're suing a municipality or public corporation or any kind of governmental entity, the state of New York, for negligence that when they were operating in their government capacity, not as a proprietor, but in their governing capacity, you always have to plead and prove special duty. And not only did they say that you have to plead and prove special duty, they've said over and over again, there's only 3 ways to do it. This goes back to a case about 25 years ago, the 3 ways to do it, called the Cuffey case. And those cases, the ways you do it, the 3 ways are special relationship. That's where the plaintiff had some kind of the district, or the government actor had some kind of direct contact with the plaintiff and voluntarily assume some kind of a duty to the plaintiff by making a promise to keep them safe somehow, or to do something that would keep them away from danger. And that they knew or should have known this could lead to harm if they didn't provide that security. And finally, you have to also show that the plaintiff justifiably relied on the promises, that because of those promises, they let their guard down and didn't do everything they could have done on their own to keep themselves safe. The next one is a statute creating a public, some kind of a private right to sue. And the third one is hardly ever comes up, is when the government official assumes positive direction and control in the face of a known, blatant, and dangerous condition. So the court has said time and time again, you always have to do one of these 3 ways. Well, the issue came up in all the appellate divisions, and you're going to see there was a split 2-2 on this. What happens in a foster care situation where a county or a state agency there's a child being neglected or abused at home, and they want to place this child with a foster family or a foster system. And of course, they can be negligent when they place them. They could fail to investigate properly where they're putting them, or they could be also negligent in their supervision of the care. And there were a lot of lawsuits, and because the court has so strictly said over and over again, you have to prove a special relationship in any of these three ways whenever the government's acting as a government. And here, providing safety to children is a governmental function. Anytime you talk about keeping the public safe, that's a governmental function. So what happened was, think about a foster care situation. There's never any special relationship formed between the child or its parent and the county, for example. They simply place these children in a home. There's no discussions. There's no promises made directly to the parent or the child. So you can't prove special relationship. The courts have said that there's no statute that provides a private right of action for foster children. And of course, it's not a situation where the government official is leading in the face of a known blatant dangerous condition. So what happened here was there was a split in the departments. The first and fourth departments were following strictly the words that were coming out of the Court of Appeals mouth, saying you always have to do it. And they said, sorry, guys, we just can't help you here because we can't, there's no special duty. And the Court of Appeals says you got to have special duty. So foster care children, you're on your own, no help, you can't sue. Second and third department said, wait a minute, that can't be the rule. And they said, and what they did was they looked at two lines of cases where the Court of Appeals, first prisoner, inmate cases. There's a whole line of cases right out of the Court of Appeals where inmates are allowed to sue when the supervision is negligent by the county or the state or whoever. Someone's attacked and that you can allege there was not enough supervision and that this allowed the attack to happen. And the courts there, the court never even mentions special duty. They just assume a duty was there. And the same thing in the school setting. A child, you drop your child off at a public school, and the parental role of supervision is replaced by the school being the supervisor, providing the care and keeping the child safe. And in those line of cases, also the court said, look, they never talk about special duty. They just assume that there's a duty. And what the Court of Appeals said here in the Weisbrod Monroe Moore case on page 61, they said, second and third department, you guys are right. Anytime the state or the county or any public entity takes custody of a person, whether it be in a school setting, prisoner setting, or in a foster care setting, the duty to care, the duty flows not from a special duty, but from the very nature of the fact that you're taking on the responsibility for them. You're basically denying them the possibility of standing up for themselves or of taking or looking out for their own care, and you are therefore substituting them, and you have a duty. And so they said in this particular line of cases, just like in school, just like in prison cases, you don't have to go through one of those three different ways of showing special duty. So foster care cases are alive and well. And for a while, it was not so clear. I think I'm pretty much done, Michelle. If you want to pass this over to my friend Danny there.
Amazing. Nicely done. Before we invite Dan up, I'm going to do our first attendance verification poll. Hang on, where'd it go? I lost it. Here it is. Okay, I'm launching it now. The question is, which upcoming annual update topic are you most excited to invite your friends to attend? See what I did there? Your options are medical malpractice. That's coming up tomorrow on the 17th. Then we've got damages or insurance law on the 21st, evidence or disclosure, or really it's and or disclosure. You can come to whichever you want. On October 23rd, premises liability and labor law on the 28th, product liability or ethics on the 30th, or all of them. All right, I'm going to let you decide which ones you're most excited to invite your friends to attend while I share some more messages from our sponsors. All right, here we go.
Before you step away, I'm an attorney in New York, and I can save you hundreds of hours per year and reduce your clients' liens by an average of over 50% at no cost to your law firm. My team at Medical Lien Agency handles Medicare, Medicaid, workers' comp, ERISA, and private doctors' liens, and we only get paid based on the successful reduction of the lien. Our services get you and your clients paid faster. You practice the law, we'll handle the liens. Contact us today.
Why does your injured client need a settlement consultant? A properly trained consultant has specialized knowledge that is vital in helping choose the right strategy. From Medicare set-asides and special needs trusts to structured settlements and market-based financial options, a consultant helps set your client up for long-term financial security. Sage Settlement Consulting has a nationwide network of industry experts ready to help facilitate a smooth settlement resolution. To find out more, contact a Sage consultant today.
All right, awesome. Many thanks to our fabulous sponsors, Solinsky.
Okay.
I didn't say your full name when I introduced you. Usually I don't, but say presenters' middle names. But when your middle name is Justice, you have to be introduced as Daniel Justice. All right, take it away, my friend.
Thank you very much, Michelle. And Mike, as always, a wonderful, wonderful job. This is my 13th year of doing this, and all I have to show for it is a couple more pounds and a lot less hair. But I want to get into it. But before I get into it, it was very important for me to bring this up. It's a public service announcement. For those of you in Suffolk County, Jake's 58 Casino is owned by the Suffolk County OTB. It is a municipal entity which requires a notice of claim. So any questions about that, give me a call. I've just been through it. Thankfully, we overcame it, but it was an issue. You have my QR code right there. You can just contact me. We're going to get into prior written notice law first, right? This is if you want to sue a municipal entity on a defective sidewalk or curb, culvert, whatever that is, or street, there must be prior written notice upon the municipal entity. Each municipal entity in New York State has now adopted this. And if you want, there must be prior written notice before any action or it can be sustainable. And these prior written notice statutes, which are written by each municipality, are strictly construed, right? They're strictly construed as to who in the municipality must receive the notification, whether it be the Department of Transportation, a clerk, a particular person within an office, a clerk's office, what have you. How they're told. Each prior written notice statute has a different manner in which they they allow themselves to receive the notice. For instance, New York City must be actually given to them. There are other municipalities, as we're going to see, which require return receipt requested, certified mail, or personal service. And what must be in that prior written notice of the defect, of the sidewalk, of the road, of the curb, must be a very specific allegation as to what is wrong, or sometimes a picture. What is being showed? What's the defect? Right? We're going to get into this Court of Appeals case. By the way, each time that I talk about a case, we're going to have the pages in bold there for what they have. The Calabrese case was a Court of Appeals case in which a motorcycle hit a pothole. And this is a pretty interesting case. It's got this is like the twilight zone of cases. There are a lot of different aspects to this thing, but the most important, and what the Court of Appeals really dug their teeth into, was this app that was used by the city of Albany called the See Click Fix app. And what that app did was basically, it was encouraged by the city, and that's very important. It was encouraged by the city to basically have citizens, as they're walking down the street, see something, for instance, a pothole or something wrong with the sidewalk, take a picture and send it along within the app, and the county would take care of it. As Professor Hutter was saying, you can get these amazing items from the from NICEF because the record on appeal of all these cases is listed there. So this is the actual on the right side here, the See, Click, Fix app that the City of Albany received. The City of Albany's statute, their prior written notice statute, said that they must be actually given something. But the question became, is this something that the Court of Appeal said is sufficient to constitute prior written notice? On the left side is the actual defect that was there. And the Court of Appeal said, yes, this can be prior written notice because the city encouraged it. It's essentially gets reduced to a writing and it gets sent to each of the agencies. And we all know, or actually prior years of litigation, 311 complaints usually don't cut it, right? And the question is, well, has this changed anything? Calabrese hasn't really changed much so far, right? This is, it's only been cited 3 times since its decision, all right? And it was attempted to be challenged pretty recently. I did a little bit of homework on this in this case called Pecora versus Village of Tarrytown. It's not in your materials, but if you want to take a look, it's 85 miscellaneous 3rd 1251. In that case, the judge had ruled that the Village of Tarrytown did not receive prior written notice by an email that it had a picture of the defect attached to it. All right. And the plaintiffs re-argued, saying, hey, this Calabrese case came down from the Court of Appeals, and that's changed things. And Judge Jameson, who reviewed this, said, no, it didn't really change things because that complaint was sent by email. And even though Calabrese may have broadened or liberated prior written notice in the terms of an app, what's important is how these things are required to be sent. And the Village of Tarrytown, unlike the City of Albany, and for the record, the City of New York, required personal service or certified mail. And they specified, and as opposed to New York City or City of Albany, which said it just needs to be actually given. So Calabrese hasn't changed much. I asked one of the attorneys involved in the case whether or not there was an appeal, and the appeal was not perfected. So we're going to have to wait around to see how broad Calabrese is going to be read. There are 2 exceptions to the prior written notice law called the Amabile exceptions, as from a Court of Appeals case from years ago. And they are whether or not there was an affirmative act by the municipality that immediately created the defect, or special use, that the municipality derives some special use from the defect. Let's go into affirmative act because there are cases that involve that here. Special use is very rare. Again, it must immediately result in the creation of a defect. As you see the illustration here, that is something that's immediately resulting in the creation of a defect, right? It's not whether or not you plant you lay down a sidewalk and over the years, wear and tear reduces the structure and the strength of the sidewalk and it crumbles beneath you. It's whether or not something was implanted wrong then and there. In other words, that there was a misleveling of the sidewalk then and there, not something that happened over time, but then and there, and immediately resulted in the danger. We're going to go over this Gubernova case, which illustrates this point. If you see on the photograph on the left, there are these bollards, right? And they were there installed into the asphalt to protect trees. In the Gubernova case, a mother and her 5-year-old son were returning from a bike trip, and as the mother was putting the bikes into the car, the 5-year-old jumped onto to that bollard and swung from it, and it collapsed. And the collapsed bollard is there on the right. And the plaintiffs in this case said obviously there's no prior written notice in this case, but they tried to establish this through an affirmative act. And the plaintiff hired an engineer who opined that the parking lot bollards were dangerous because when they were implanted, they were put into the asphalt, and that asphalt is very unsteady. right? It should have been put into concrete. And because it was put into the asphalt, they said the asphalt wasn't dense enough and this was an accident waiting to happen. But the third department said no. They said that even though it may have been put into something that was unsteady or insufficient to hold the ballard for a long period of time, that's still wear and tear. It did not immediately result in the existence of a dangerous condition. Over in the first department, again, these pictures are all from the record on appeal. I encourage you, if you're interested in the case or you want to see what they did and what you could possibly do differently or the same, you should take a look at those records on appeal. In this case, when streets are repaved in the city and usually anywhere else, in order to protect motorists from the manholes that are in the roads, they must ramp up asphalt around the manhole to protect the tires so that the tires roll over the manhole. In this case, the plaintiff basically said, yeah, that was done, but this was ramped up improperly because the plaintiff, who was a passenger in a car, had that car roll over the manhole, which was not properly ramped up, and it literally hit onto the undercarriage and deployed airbags. It was strong enough for that. So that was the plaintiff's allegation, and basically the court said, yes, the improper ramping up of those manholes immediately resulted in the existence of a dangerous condition. And in this case, the case was allowed to have an issue of fact as to that issue, and summary judgment was denied. All right. This is a very interesting case too, and this provides, in the event that you don't have prior written notice, and the event that you don't have an affirmative act or a sufficient affirmative act, there might be a third remedy for a private contractor, right? In this case, Callahan versus the County of Nassau, page 83 of your materials, the plaintiff was walking on a section of sidewalk which literally crumbled beneath his feet. And the reason why it crumbled was it was poorly repaired, right? Or at least that was the allegation. The town hired a private contractor who the plaintiff, and it's a good thing he did, brought into the suit. So he sued the municipality and the private contractor. And the plaintiff alleged that the private contractor negligently performed the repair. The defendant was out, right? Even though the sidewalk had crumbled after a fairly short period of time, it was still based on wear and tear, and it wasn't immediately apparent upon installation. But the plaintiff was able to keep the contractor in, right? Because the contractor is not viewed through the prism of a prior written notice law where you have to overcome it by showing this affirmative act, which is immediately noticeable, right? They can do it just by poor repairs or poor maintenance, and they'll still be liable. So even though the town was out, the contractor, in this case, was still in. And that's a very helpful piece of advice if you're working on a case that you don't have prior written notice or an affirmative act so clearly. Again, I've said it before, I'll say it again, and every year there's at least one or two cases. If you're going to use one of those Amabile exceptions, special use or affirmative act of negligence, they must appear in the notice of claim. If they are not in the notice of claim, you cannot use them later, right? So if you're drafting a notice of claim, if there is a way you can articulate a special use or an affirmative act, make sure you do it. One of my favorite sections of the law, hello, Mary Man, we've been dealing with this for a while, is Highway Law Section 139.2. In that case, in that statute, this is the statute that gives counties, and we're talking about counties not including New York City, right? And usually city counties are exempt from this to some extent, not including New York City. But this gives the counties the right to enact prior written notice statutes, right? And this highway law section says if the highway is, if you want to have an action against a highway in a county, you must have that prior written notice in place, right? And a county is allowed to do that. However, in the event that there is no prior written notice, and only for counties, this law allows constructive notice to work. And that's a huge boon, and that's very helpful. So where there's no prior written notice as far as the county is concerned, and we're talking about a roadway, constructive notice applies. Now, there's a split in the departments as to how far this reaches, right? There's a second department case called Zash, which was decided in the 90s, which basically says that this highway law is section 139.2 is confined only to roadways and no further. But 2 years ago, there was a case called Hart from the fourth department, which examined Zash and said, no, we read this as being much more open. Not only is it the roadway, but anything connected to the roadways. So curbs, sidewalks will be under this law. So you can essentially start, at least in the fourth department, a case against the county for a sidewalk defect where there has been no prior written notice, but there's constructive notice. There is at least one case that's pending right now in the second department, asking the second department to revisit this, but we'll have to see what happens on that on a future date. And an example of this is Gas versus the County of Rockland, page 90 of your materials. In this case, there was a pothole on a county road, right, and no prior written notice of the pothole. But, and if you take a look, the the word school was painted on that road, and literally, if you look on the screen to the right, right over the pothole. Right, this is one of those memes that is not my job. Right, they literally painted school right over the pothole, and the courts held that that was sufficient to establish that there was constructive notice on the county of Rockland, and the case was allowed to proceed. I'm going to go into school liability now, and we're going to start with the assumption of risk. Even though the assumption of risk doesn't always involve schools, it tends to overlap because of the amount of sports that are played in schools. And we're going to start with the first, I believe this was the Court of Appeals case of Maharaj versus the City of New York, page 100 of your materials. In that case, a cricket player was injured in a city park after he was running to catch a batted ball and tripped and fell over a cracked asphalt. As far as the Court of Appeals was concerned, the majority held that this was classic assumption of risk, right? It didn't enhance the ordinary risk of playing the sport, right? This was just something that they are assumed to have looked at and considered before playing. There was a vehement dissent, as there always is in these cases, the assumption of risk cases, by Judge Rivera, who basically said, hey, listen, playing at your own risk doesn't mean that the landowner should get a free pass, and she dissented in this case. That is for the players. Usually the third party, a third party participant, meaning a spectator, might be deemed also to assume the risk. And I know that personally. Unfortunately, my son was a victim of this down in Port St. Lucie spring training right around the COVID time. But if you're a spectator, there's usually something on the back of the ticket or some understanding that you are assuming the risk of something coming out and hitting you. But what about a non-spectator? And this is an interesting case in the third department called Hankey versus Ogdensburg City School District. In that case, there was a hockey rink within the gymnasium. At the same time, someone was delivering food for a party the next day, and he was told by the school, by actually one of the custodians in the school, exactly where to stand and exactly where to deliver food. While that's happening, the kids who are playing hockey are hitting slap shots against the goal and trying to outdo one another, despite being warned that they shouldn't do that. And this becomes a hybrid assumption of risk negligent supervision case. The third department said, well, this is not assumption of risk on behalf of the non-participant. He was simply told where to go. He had nothing to do with the sport, nothing to do with the game. Was simply told where to go by the custodian, as he didn't assume the risk. The other question then became, well, these students were warned against hitting these slap shots. Does that now open negligent supervision? And it was deemed to do that. Summary judgment was denied. Right? These are the three guys from Slapshot, right? Negligent supervision foreseeability, right? So we transition from assumption of risk to negligent supervision. And negligent supervision almost always turns on foreseeability. And remember when you were in law school and your professors would say, hey, hard facts make bad law? This Porsche case may be that situation. This was an awful case where children, and actually one child in particular, subjected other children on a bus between kindergarten and second grade, and he was a kindergarten and second grader himself, to sexual abuse. And it was unimaginably awful, rather. I'm not going to go over all the facts in it. If you're interested, take a look at the case. It was horrible. And in this case, the case really turned on the foreseeability. Was this, over these 2 years, should the school have known about this or seen this? And it was interesting. This turned on the deposition of the principal, who was asked two specific questions: whether or not he was aware of prior sexual-based incidents on the bus and prior sexually based incidents in the school, prior sexual violence. Those are the only questions that the principal was asked. There was no affidavit from the principal regarding any other knowledge he may or may not have had. And the court said that the defendants did not establish that this was not foreseeability because of the way the principal answered the question, right? The principal should have been asked, or at least should have established, whether or not there was any prior acts of sexual conduct that they knew about. This is a difficult one because a lot of other cases in this line of cases really turn on to whether or not the school had knowledge of the specific propensity of the student. And this seems a little bit general. But again, as they say, hard facts make bad law. I don't know that this is bad law, but this was a tough one. But this is definitely one to read if you want to get into one of these foreseeability cases. All right. Another one, Moyse versus the City of New York. This was very interesting. This was when students from a particular city school district were like kindergartners, they would take pictures on these monkey bars at this park that was off school grounds. And it became a tradition that they would always go back to that school, to that playground, and take pictures in the same manner that they were on top of the monkey bars, right? And unfortunately, the monkey bars collapsed under the weight of these students. These were, for children. This was a very small monkey bar set, and I'm going to show you some pictures of it. And the court said first of all, was this involved in the scope of what the school does? And it turned out that the school actually provided the cameras, the school provided the uniforms for the children and knew about this particular tradition. And because they were going to a park, it was foreseeable that this monkey bar set would collapse under the weight of the 11 children. Again, taking a look at the record on appeal, this happened as the picture was taken. So on the left is before, as the children were getting onto the monkey bars and posing. And then this is the after picture, or as you see it's happening, you can see that the monkey bars collapsed and literally fell on the students underneath. Again, take a look at the record on appeal if you're interested in these cases, because there's a lot there. Next up is emergency vehicles. We're talking about the qualified immunity of police vehicles, ambulances, and fire trucks, and what happens with them. And the VTL and case law have basically said that if you're one of those three emergency vehicles and you're responding to an emergency call and you have lights and sirens activated, although police are exempt from that because they need the ability to be able to sneak up on criminals, but you're responding to an emergency call and you have your lights and sirens activated, you will be judged under a different prism than anyone else driving a car. Anyone else driving a car, we're talking about you or I with ordinary negligence. But somebody who's protected by this qualified immunity will experience, instead of ordinary negligence, they will get the benefit of you will have to prove reckless disregard, which is a very high standard, okay? Now, if you're responding to an emergency call and the lights and sirens are activated, you have not yet satisfied the statute. If you're doing those things, you can satisfy the statute by violating one of these four violations of the VTL. So in other words, you have to break the law in order to get the benefit of the statute, right? And one of the laws, one of these four items must be the thing that caused the injury of the plaintiff, right? Stand, stop, or park anywhere. Run a red light or stop sign. Exceed speed limits as long as it's not endangering life or property and disregarding the direction of movement or turning. If you have your lights and sirens on and you're responding to an emergency situation, only if you're committing one of these violations do you get qualified immunity and judged by the reckless standard, right? Let's take a look at Nicholas versus Robillard. This is on page 92 of your materials. This illustrates it. An ambulance was responding to an emergency call, had its lights and sirens on, right? It moved into oncoming traffic to get around a slow-moving car in front of it and hit the plaintiff's car head on. The plaintiff sued, and the court said that the defendants were entitled to this privileged conduct under 1104B4 because it was disregarding the direction of movement by going into the other lane, and it did not rise to the level of recklessness. Another case, this was interesting, Hannah versus City of New York. I think the court came to the right conclusion, but I don't believe it was correctly decided. I want you to take a look at this if you're interested. Basically, a police car was proceeding through an intersection. There's no indication that the police car was running a light, was speeding, or involved in any of the other maneuvers. But the plaintiff made a left turn in front of the police car and was hit, and the plaintiff sued, right? And the court said, and I took a look at the lower court, I took a look at the court at the second department. The court held that because the police car was responding to an emergency, that it would get the benefit of 1104B, that it would get the benefit of the reckless endangerment. But it did not say which one of the four maneuvers it violated. And I don't think it did. But what the court also said was that the plaintiff, by making a left turn in front of that car, was the sole proximate cause, almost like a labor law term, right? And because of that, the plaintiff could not recover. And if that's the case, I agree with that, but I don't agree with how they got to that decision. Related to 1104 is 1103B.
Hey, Dan, I'm so sorry. I got to jump in for a second. You were doing great, and I was into it, and I forgot that it's almost 2:30. So I need to do our second attendance verification poll, but nobody should leave. If you can stick with us, there's going to be plenty more, and you can earn an additional half credit. Because Dan's going to wrap up, then we're going to get into Q&A, and we're definitely going to go till 3 o'clock. So stick with us. But in case anyone has to go, here is your second attendance verification question. The question is, how can I see the world while earning CLE credits? And your answer options are join the Academy on one of our upcoming 2026 trips open to Academy members and their guests. Our journey to northern Morocco and the Sahara is going to be January 24th through February 3rd. You can also learn about law and culture in Sicily coming up April 15th through 22nd. You can choose I can't miss Morocco, please email me the details, or I must see Sicily, please email me the details, or both sound amazing, please send me all the details. And we will, and they are so fun, and you should all come with us. Okay, Dan, sorry, back over to you.
That's okay. So Michelle, what I think I'll do is I'll go to my last subject, if that makes sense, and then we can always, if you want, I have more material, but I definitely want to get to at least one more subject and then move on.
Hit it.
Perfect. Okay. Let's see how to get back onto this. There we go. Okay. 205A and 205E, these are claims by on-duty firefighters and police officers, or as I call it, the greatest gift to the plaintiff's bar since the scaffolding statute. In this case, in these statutes, if you represent a police officer as a plaintiff or a firefighter, and they're injured in the line of duty, and that injury is based on a violation of a codified set of rules or a codified statute, it is essentially strict liability as against the firefighter, the violator of that statute. And there is no comparative negligence. This is one of these things that if you happen to represent a police officer or a firefighter who was injured in the line of duty, one of these things to look for. It makes the case a lot easier, and there's a lot of very healthy girth of case law on this. So in order to do this, you must be able to identify the statute of ordinance, right? It can't be something from like the patrol guide or some sort of side ordinance. It's got to be an ordinance or a statute or law. You have to describe in your pleadings the manner in which the firefighter or police officer was injured, and set facts from which it may be inferred that the defendant's negligence directly or indirectly caused harm. There is essentially a relaxed proximate cause standard on these cases. So the question then becomes, should this be established in the notice of claim under 205A and 205E, right? Traditionally, yes, there are cases that say 205A and 205 or 205E must be established in the notice of claim, not mentioned, not merely mentioned, but established. Like you must go through what statute it was, how it indirectly or directly caused the injury, and who was involved, right? Good practice says that this must be done. But the second department said no, right? Mitchell versus Jimenez, pages 111 to 112 of your materials. Plaintiff police officer was a passenger in his partner's vehicle and was injured when the driver of that vehicle caused an accident. In New York City, NYPD officers can sue the city, right? They're not bound by the workers' comp bar. It's 207C, which is a little bit different. But in this case, the 205E did not appear in the notice of claim. The notice of claim was timely filed. It did not allege 205E, right? It did allege statutes, but it did not allege 205E. So let me just have to click out of this, right? So a lawsuit was commenced more than a year later. The plaintiff moved to amend the notice of claim and the complaint to allow for the 205E, and the court said that is not necessary. There's no need to amend it, as the allegations in the notice of claim were sufficient to alert the city that this was a potential cause of action. Now, that might be acceptable, but good practice dictates that if you have that 205E or 205A claim, don't just rely on Mitchell versus Jimenez. Make sure that you establish it in your notice of claim. You don't want to have any sort of risk that 205E, because that statute is so helpful to the plaintiffs, and it can only help. And Michelle, with that, I am done.
Amazing. All right, let's see if we can get Bersani back on here too. Let me do gallery. Where'd he go? Is he still there? Yeah, there he is.
He's coming.
Coming back. There he is. All right, let's stop your screen.
Great job, Danny.
You too, Mike. Thank you.
Yeah.
Bersani, you've been banging out the answers to the questions in the Q&A. So do you want to just talk about any of them?
Well, I'll tell you, well, let's, I think we should, so everybody should know that I was asked questions and I answered them, and you could read them. And if you have more questions about my answers, that'd be great. But maybe we should turn it over to Danny, because there's a bunch of questions I think here for Danny too. And if Danny's done and there's more time, I'll go through some of the more important, what I consider most important questions. Okay? Is that good?
Sounds great to me. You guys rock it out.
All right. Do you want to, I'll go through the, let's see, I'm just going to go in order as they appear. This is from Mark Birnbaum. In the situation where the municipality controlled manhole is left open, would the prior notice requirement prevent the first claimant from prevailing? Well, meaning left, I'm not sure if you were referring to the prior, the case that I was just deciding, but if a municipality controlled manhole is left open, prior written notice does apply unless you can, and I had a trial like this actually a few years ago, where you would have to establish an affirmative act on behalf of the town if you don't have that prior written notice. But yes, it would apply. Hey, Gilbert Hardy, excellent attorney. I got around prior written notice when the client fell at town hall and their witness admitted that his job was to walk the grounds and look for defects. I'd love to talk to you about that one. That sounds interesting. I don't know that that's necessarily going to work every time, but if it worked, I'm happy that it did. From Robert Stein, are there any municipalities in New York State other than the city of Albany that have the See Click Fix app? The answer, I think, is no. I actually looked at that. I think Boston, Massachusetts, and 2 other states have it, but the city of Albany was the only one that I saw. I would take a look again to see if it's been expanded, but given the Calabrese decision, I would think that any municipality is a little reluctant to have anything like that. They don't want to widen their exposure to liability by adding this app. 311 has become an app, and look, New York City has that the actually given manner of delivery of the prior written notice. So I'm just curious to see why there hasn't been more challenges to that since Calabrese, but time will tell. Nicholas Massimo, can you please provide the Anderson case, the site to the Anderson case again? I can. I'm going to have to open my PowerPoint really quick. I'm going to look for Anderson. Let's see. Anderson. Da, da, da. Anderson was 234 AD 3D 902. It's on page 85 of the materials. That's 234 AD 3D 902. Marav Deckel. Can the city rely on the Big Apple map for lack of notice, even though the Big Apple map is no longer active for years? The defect could have occurred between the time the Big Apple map stopped existing and present. That's interesting. The city, yes, most plaintiffs rely on the Big Apple map to establish unfixed defects. However, the Big Apple map, what the city's been doing lately is showing through like Google Earth how since the Big Apple map came up, a particular defect has been remedied, and that's been held sufficient. So you have to be very careful using the Big Apple map. Of course, the defect could have occurred between now and then, but the Big Apple map only goes until I want to say 2003. Can you amend, this is from Sarah Policiano, please forgive me if I've mispronounced that. Can you amend a notice of claim pursuant to GML 50E6? What would constitute mistake, omission, irregularity, or defect? I think, Mike, I'm going to turn that
Yeah,
one.
I'll handle that. Essentially, that particular subsection allows you to amend the complaint if it is only a technical change or a minor change that doesn't impact the city's prior ability to investigate. If it's a new theory of liability, forget it. If it's adding a bunch of new facts, forget it. If it usually is used for something if you got the date a couple days wrong, but the municipality still had a chance to get out there and could figure it out on their own, or maybe the place was a bit off, that kind of thing. But again, technical changes, minor changes, not new facts or new theories.
Okay. And Mike, I think the next one is you too. It looks like a governmental immunity case.
Okay, let's see that one here. Read that for me, Dan. I can't find the
Sure,
place.
sorry. This says plaintiff unconscious at the scene of a motor vehicle accident. EMT intubates despite the fact that plaintiff is breathing on his own, but puts a breathing tube in the esophagus instead of the trachea and does not fit, I guess. Has a myocardial infarction on the way to the hospital and has significant brain injury from the lack of oxygen. Isn't this custody of person who could not now breathe on his own, meaning no need for special duty under Weisbrod more?
No. What happens there is when you have medical care, there's a case a few years ago, the Court of Appeals case, that when the government, like for example, a hospital is considered a proprietary care that are being given by municipalities. So you don't even have to show special duty for something like that. But the cases we've seen regarding the line of cases you're talking about, ambulance and stuff like that, you definitely have to show special duty, and you can show it. I mean, it's not a custody situation in the sense that prisoners, school children. It's basically when you go to a doctor and you're getting, are you in the custody of the doctor? Not really. I mean, it's a nice argument. You're stretching that word custody a lot, and who knows, maybe you can convince a court to buy that. But right now, the law, all the case law I've seen on ambulances, EMTs, that's not case law.
Steven Siciliano writes, are fire trucks afforded qualified immunity when they are returning to the fire department, or is it only when they're on their way to a scene and when they are there? It's not when they're returning to a fire department, because they're not responding to an emergency, and presumably they won't have their lights and sirens on, so that would knock them out of the qualified immunity. Simply being a fire truck doesn't afford you those rights. The second one, it's a notice of intention to claim. So that's Court of Appeal. So that may be me or Mike here. This is from Robin Zimpel. If a petitioner serves a notice of intention to claim in order to preserve his rights, does the petitioner then have to seek leave to serve a late claim, or can he just go ahead and serve the claim? So that sounds like a court of claims issue. And yeah, if you serve the notice of intention within the 90 days, you need take no further steps until then you have 2 years from the date of the claim.
That's
Yeah,
right. That's right. You don't have to move.
right. It looks like this next one is going to be a notice of claim question for you, Mike. I'll read it for you. It's from Gret Becht. I can understand how late notice would be a nullity for a notice of claim requirement, but seems like it should still give knowledge within 90 days.
I agree with that totally. In fact, I was very surprised with the way the case law has been developing over the years on this. The court for many years has said that a notice of claim filed without leave is a nullity. But I assumed that meant that you can't count it as a duly filed notice of claim, and you have to move, you have to bring a petition sometime before the statute ends to have that be considered timely notice or to serve a new notice of claim. I never really fully understood until recent cases have come out that the courts are now saying that it's not only a nullity in that it can't count as a notice of claim timely served, it can't even provide actual knowledge of the essential facts of the claim. You can't rely on that at all when you're later bringing a petition to late serve the notice of claim. It's not fair and it's not right, but it's the way the law is right now.
Right. Linda O'Gorman, I think this is going to be a hybrid question. I think I have the answer to this too. Writes, 10 years ago, a fourth grader is hurt at school due to negligent supervision, just turned 18 years old. Can a motion to file a late notice of claim be filed? My understanding is no, because the notice of claim has to be filed. A statute of limitations is told, but the notice of claim,
Yes.
my understanding, won't be told.
Yeah.
So you may be unfortunately out of it on that one, Mike. I want.
Yeah, you have to. Yeah, the 90 days is never told. Okay, but for example, infancy. That's one of the factors the court can consider in deciding whether to grant your you leave to late serve the notice of claim later on. And you do have, with, for example, an infant, the statute of limitations is told until the child is well, it was like 19 and 3 months old if it's a regular negligence claim. So it gives you more time, but you still want to get this done ASAP, obviously, because the courts will look at the main factor they always look at is whether the municipality had actual knowledge within a reasonable time after those 90 days.
Okay. Lawrence Singer writes, no conversation regarding medical malpractice late notice of claim against municipal hospitals. I think there's some in the materials. We just can't
there is
get
in the
everything.
materials.
Yeah.
So the issue, the interesting thing about those medical malpractice cases is the way you give actual knowledge of the essential facts of the claim is different from all the other cases. What the court looks at there is they look at the actual medical records, and you're going to have a medical doctor put in an affirmation in your petition to late serve saying that those medical records show any reasonable doctor reads that they can see the malpractice, that the malpractice is obvious or evident from the records themselves. And the records, since those happened within the 90 days, or in fact immediately, the court will impute actual knowledge of the essential facts of the claim to the municipal hospital.
Robert Weiss, this is something I actually know a little bit about. New York City has cyclomedia. This is from the Zola, Z-O-L-A webpage. A private company photograph all the properties in New York City, and sometimes the photos capture defects. Are you aware of any case law about this, and do you have any thoughts about it? As far as I know, these photos are from the Department of Buildings and not the Department of Transportation. Well, these typically, first of all, Cyclomedia and Zola are terrific, terrific resources. My understanding of 4532B, which is the mechanism by which you can essentially use a Google photograph or other satellite photograph or like a Google Street View to establish not prior written notice, but basically to make it legally noticed that these however it appears in that photograph is the way it looks. And right, the court will take judicial notice of that, just like they would in 4532B. But I haven't seen any case law using it, but I have used cyclomedia under 4532B as essentially a satellite photograph to establish the condition of a certain property. So, but I haven't seen anything yet on any cases handling that. Jonathan Summers writes, can special use be established with a pothole on a designated crosswalk and immediately adjacent to a designated crosswalk? My understanding on that is no, unfortunately. Even though the pothole is in the crosswalk, special use has a very specific meaning when it comes to prior written notice, and it's almost exclusive use of the municipality. So, for example, like a sewer system could be deemed, although that's actually for public, like a city system that involves the subways, right? It's not meant to be open to the public, but like a manhole contains those products or something regarding the subway. That might be something that you can say, hey, there's a special use and you don't need prior written notice for that. But for the most part, simply because it's a designated crosswalk, that's open to the public, that's for everyone's use. There's no special use on the city. The next one, this is going to be for you, Mike. This is regarding pre-action discovery. I believe it's going to be about that Jaime case. I seem to recall that you can make a motion to conduct pre-action discovery in order to frame a complaint. Don't recall the CPLR section?
Yes, I do. It's 3201, I believe. I believe in the written
3102.
answer.
3102.
Did I get that right?
Yeah, just almost. Yeah, you did the same thing I did with 3126.
Yeah.
It's 3102.
3102.
Yep.
And it can be used in order to help file or draft a complaint because you don't know who the defendants are. And the case law also says for a notice of claim, for leave to serve a notice of claim late, you can use that statute to help you develop evidence that the municipality had actual knowledge of the essential facts if you're petitioning for a late serving.
The next is from Steve Siciliano. Does the New York State Vehicle and Traffic Law 388, vicarious liability and/or respondeat superior, apply to municipal cases, or is that only for private employers? I believe that would apply. 388, my understanding, is really just imputing negligence on the owner of a vehicle from the driver of the vehicle, no matter the situation, unless, of course, the car is stolen. But I believe it would, it's just if the city owns it and a city employee is driving it during work, I don't see any reason why it wouldn't be imputed on the city. Okay, the next is a kind of a comment there. It says, Danny, how did you get so handsome? No. The next one is, this one is going to be for you, Mike. It says, Maya Kogan, is prior written notice required for a sidewalk defect in front of a hospital where the city of New York owns a lot and this hospital is operated by the New York City Health and Hospitals Corporation? Well, actually, that's both of us, sort of.
It's probably more you, but
Yeah. So yeah,
I would think so.
Yeah, absolutely. You're going to need prior written notice if the city owns it or not. Even if the city is acting in some sort of proprietary capacity, they still have since they own the building, they do get the benefit of that prior written 90 days. I remember researching that issue for a friend of mine who had a case like that, and yes, unfortunately, they are subject to the prior written notice. This one I think is going to be for Mike. It mentions a case that you discussed from Dennis Herman. I'm going to do some research on this. Preserving information is not the discovery you mentioned in Wyszynski. You mentioned discovery to identify who had knowledge. I was successful using this section. In one case, I had a 2-year-old injured in a daycare center. We really had to know how the accident happened to bring a case, whether there was improper supervision, to see the school's video. I framed my pretrial motion that I needed to see the video to frame my pleading, whether the frame it as negligence or intentional torts or a products case. That was enough to get the video pre-filing, and there was lack of supervision shown in the video, and I collected a nice sum from the daycare center. Well, I guess that's more of a comment.
Yeah, good for you.
Yeah, good for you.
Good for you. Normally, I don't think normally you can get pre-suit discovery to develop theories of liability against someone. I think generally speaking, it's to find out who's liable in the normal course of things. But it's interesting you were able to do that. And yeah, send me a link if you got a published case or something. It'd be great to look at that. Yeah.
Absolutely. The next one is from Steven Siciliano. Are garbage trucks considered hazard vehicles like snowplows and provided qualified immunity? This is on 1103B, and in certain circumstances they are. It depends what the work they're doing and whether or not it has to do with the roads that they're working on. Very often plows are strapped onto these garbage trucks and used in that manner, so that there are times to do it, but it turns more on what the vehicle is doing rather than the type of vehicle involved. Linda O'Gorman, follow up to the infant case. So file the summons complaint ASAP now that the kid is 18 and we are still within the year 90. Do we move just to file late notice of claim and then the defendant will move to dismiss?
Well, you bring a petition to late serve a notice of claim. You got to try to prove all those factors the court looks at. The main one being that they had some kind of actual knowledge of the essential facts within a reasonable time after the 90 days expired. There's other factors I'm not going to go into here, but if you read the case law and the statute, they're pretty clear. And what will happen is your petition will be opposed by the municipality, and they'll basically argue that those factors don't add up, and the court should deny you leave to late serve a notice of claim, and you'll never even be able to file a lawsuit because you can't file a lawsuit until you've either served a timely notice of claim or you got leave to serve a late one and served it. So you can't even, your suit's dismissed before it ever started.
Matthew Kaufman writes, would HIQA, H-I-Q-A, New York City, identification of a pothole and then not being repaired be sufficient? That is the job of HIQA. Unfortunately, from what I understand, no. You still need a written notice by an external force or an external person to give that to you. The internal, I don't know, is going to constitute prior written notice.
Yeah, there is a case. There's cases about 6-7 years ago on that. If you research it, yeah, that's the answer.
William Pagan, can you provide more information on Zola Media? It's Zola, Z-O-L-A, Zebra, Oscar, Larry, Adam. Look it up. Just write Zola on your search bar, and it'll come to it. It's a municipal thing. It's an orange sort of icon, and it has Cyclomedia on it. And just reach out to me. Any questions? You can call me at 212-671-1110 if you have any questions on that. Robert Fellows, the force of Rockland County, writes, one of the great attorneys out there. Does the section Dan cited highway law referring to constructive notice apply to state roadways? Unfortunately, no. However, the highway law 139 sub 2 only refers to county laws and essentially is prior written notice or constructive notice. But with state roadways, right, prior written notice does not apply to state roadways. You don't need prior written notice when you're litigating a state case. Constructive notice will be sufficient. So even though it doesn't apply, it's essentially the same condition. Kenneth Cooperstein, it says, is the failure of the county to timely deliver a tax deed of proprietary failure, or is a special duty required? That is Mike Bersani all over it.
I would say it's governmental. Who does taxes other than the government? That's a governmental function. Now, you might be trying to ask me whether it's ministerial or discretionary. Okay, because once you get past, whether it's governmental, you still, if it's ministerial, you might be able to bring a claim. If it's discretionary, you're out of luck because the government's immune for discretionary activities. That sounds to me like it's ministerial. So you could have a claim as long as, but then you got to go through the special duty thing and all the rest of that. Yeah.
Michael Sortino writes, for Daniel or Michael, does prior written notice under Highway Law Section 139 of a defective, unsafe, dangerous, or obstructive condition also apply to design defects in a highway and the potential need for a turning lane to be installed upon a county highway that is not currently in existence? Thank you for your thoughts. This is a wonderful presentation. We love to hear that. Well, Michael, for my part at least, that kind of gets into a different area, right? 139 is really just the authority of the state to give the counties the right to establish a prior written notice. And for counties, you're allowed to basically exclude the prior written notice for constructive notice. What a highway design is sort of a different ball of wax, right? The highway design and something that should have been there really turns upon the notice of or the prior attempts to correct something like that, whether or not there was a study, a traffic study in that area. There's a very different thing that you're looking into rather than the prior written notice things. Take a look at the materials. I think it's either mine or Mike's or both regarding the prior regarding governmental immunity when it comes to road design. Matthew Kaufman writes, with HIQA identification of pothole, I answered this one already. This is the job of HIQA. I don't believe that simply the internal identification of a pothole would be sufficient to establish prior written notice. Jared Bellato, looks like this is going to be for Mike. Do some governmental entities have 30 days for notice of claim and not 90 days? And how does one determine that information?
That used to be the case. About 5-6 years ago, they amended the statute so that it's 90 for everybody.
Yep.
The only thing you have to watch out for is the New York, when New York has some joint entity with New Jersey. I think they're down. I'm not a downstate lawyer, but I believe that for maybe the subway system where it's linked with New Jersey, the New Jersey statute, the New York statutes, it may be shorter or longer. But if it's a purely New York entity, it's always going to be 90. In the past, for public authorities, a lot of them had their own statute that said 30, which are really annoying and caused a lot of malpractice to happen, but not anymore.
Amazing. I'm going to jump in for a quick second because it is very close to 3 o'clock. So here is everyone's bonus question for sticking with us through the Q&A portion of municipal liability. You've earned an additional half credit. The question is, this CLE series is fantastic. How can I access more great CLE programs? And your answer options are log in to trialacademy.org, navigate to our on-demand library under education. There you can search by credit, type, topic, course title, or presenter, including Solinsky and Bersani, who have many Academy credits to their names. Or your last option there, it's free for Academy members and $75 a course for non-members. Really, you might as well join. I also added a couple things in the webinar chat, the link to join, the access link to our annual update compendium, the access link to our Gavel Drop, which is a members only Academy publication. There's a new one coming out today. There's the other things you also get access to, including CLE Abroad and our on-demand programming. And then I also put in the registration links for the rest of the annual update series in case you're not yet registered, and for the upcoming newly admitted attorneys get their stuff done before the rule changes series. All right. Are there any other questions you guys wanted to hit before we wrap up?
Looks like there's a bunch more.
I know there's a bunch more. Is there like one or two favorites that you want to hit before we say goodbye?
I don't.
Or anything else you want to say?
Well, I mean, I'm sure Mike. I speak for Mike, and I hate to speak for another terrific attorney, but you can always contact us directly if you want to
Yes,
have
good
any of these
idea.
questions answered. You can reach me at 212-671-1110. And Mike.
Yeah, you can reach me at 315-246-5944 or email me at bersani@mbk-law.com.
Okay.
Perfect. For anybody who's like, the poll isn't popping up or whatever, the poll is functioning currently and 900 something of you have already answered it. So it's there. It's probably hiding behind another window. But for anybody who had any issues with poll questions or anything else, you can always just email us. info@trialacademy.org is the best place to email us if you have questions about credit or joining or want to get in touch with Mike or Dan or Professor Hutter or anything else you need help with. We'd be happy to help you, especially with helping you become an Academy member. All right, we're back again tomorrow. Same bat time, same bat channel. We're coming back with with medical malpractice liability. Municipal was today. It's not great when I'm already confused and it's only day one. Tomorrow is medical malpractice with John Bonina and Jenny Fay. So hopefully you'll all be back for that. And then next week we hit another 4 topics. And